Lara, let's break down what he's saying. Again, it can sound kind of wonky, but it's really, really important. When the appellate court ruled and reversed the trial court in the Chauvin case, in this case, they did it really on procedural grounds because, as Neil Katyal says, the trial judge said, I don't agree with this Noor decision. That's a previous case. I agree with what the dissent said, and essentially said because the Supreme Court has not yet ruled on it, he was going to throw that third-degree charge out. So the argument by prosecutors is no, that is a precedential decision. It's got precedent because it was from the appellate court. And that's what the appellate court pretty much rebuked the trial court judge in that decision and said, no, you have to follow that precedent. But again, I want to get into why this is so important, because on the third degree charge, while there's no intent that's required, it's an act that is eminently dangerous to others, plural. It doesn't say another, it says others. And so I've looked up a number of cases here from Minnesota, and a number of them seem to have always indicated that it would have to be with respect to the actions were focused not on a specific person, but others. And apparently this Noor decision changed that in the appellate courts. And yet again, I say it has not yet been decided in the Supreme Court. I mean, this is a really nuanced but important issue.
A very important issue, because if we're talking, if the trial court is correct and the Supreme Court ends up affirming, basically, actually, the Supreme Court agrees with the trial court and says, no, this has to be directed to a number of people, multiple individuals, not just one individual, then you know what? If the third degree murder is allowed in, then it's problematic to the defense. I heard the special prosecutor saying, we've only got this one shot to get this third degree in. Mr. Chauvin can later appeal it. So if we're incorrect, if the appellate court is not correct, then maybe later he's got remedies. But wait a minute, maybe he forgot something. The defendant is entitled to a fair trial. It's not the prosecution that's on trial; it's the defendant that's on trial. And the judge, it sounds like the trial judge here is basically following what most of the courts have followed. I mean, it looks like it's been interpreted previously on many, many occasions as applying to plural complaining witnesses or victims or deceased or whatever, a group, not just one individual. And like you said, Bob, the appellate department, the appellate court suddenly changed that. Well, it's very likely that the Supreme Court of Minnesota may not agree with the appellate department. I understand it's got some precedence, but at the same time, there's a lot at stake here, and it would make sense to see and not take a chance on the fairness of the trial involved here.
Yeah, I agree. And Alan, as a prosecutor, I just don't want to be in this world where our trial, where I've got a